All here. You have a little different background than normal. We're at a firm today before another meeting here. They kindly let us use their space. So thanks to Sidley Austin for hosting today. And we are going to be talking all about the topic of third country removals and refoulement, something that's very top of mind for a lot of litigators and immigration advocates right now. So I'm really grateful to be with my colleagues today, Amelia and Genesis, who are doing these cases and have a lot of intel to share with you about the latest strategies that we are testing here at Amica Center and working with other partners on. So before we dig in, I'll just share a little bit about the Amica Center and our Immigration Impact Lab team for those who are new to our roundtables, if this might be one of the first ones that you're joining. We are a nonprofit based in Washington, D.C. and Baltimore. We represent immigrant children and adults who are facing and at risk of detention and deportation. Focus really on the DMV area, but we work around the country now given the transfers that happen. So we're very focused on more mid-Atlantic and increasingly more Southeast as we have clients transfer there as well as other states. And so we do these roundtables as part of our Immigration Impact Lab. We can go to the next slide, please. Thank you. This is our smallest program. So Amica Center is primarily direct services, deportation defense organization, and then our lab team does impact litigation. We focus on things like habeas petitions, class actions, appeals, with the goal to try to create better precedent for broad groups of immigrants. We also do a lot of defensive work right now, which involves suing the administration on various issues. And if you have any cases you'd like to refer over for impact litigation, please feel free to refer to us at lab@amicacenter.org. Thank you. A little bit about our approach, although this is always evolving, but when we do cases in the appeal route, we often start off at the immigration judge level, working closely with our detained adult program here that Genesis works in, and we will work with that program to bring cases to the Board of Immigration Appeals and the Federal Court of Appeals for petitions for review. When we get positive decisions, we're able to make regional and sometimes national impact, more for our nationwide scope cases that are brought often in district court. And next slide, please. And I will now pass it over to Amelia, who's going to kick us off for this discussion on third country removals and refoulement.
Hi, everyone. Thank you so much for joining us today. We are really excited to talk about this topic, not because it's actually a wonderful topic to have be part of our experience right now, but because it is so relevant and because it is happening at such frequency. We think it's really important to come together and share our experiences about what we're seeing, what we've learned so far in the third country removal kind of experience, and also to offer an opportunity for all of you to share your own experiences, what you're seeing, what's been working, what maybe hasn't been working, what we can all learn from together as we're all experiencing this and kind of witnessing this happen to our clients. So to kind of give a little bit of an overview as to where we're going today, we are going to start with a brief overview of the law. What is governing these third country removals? What allows for DHS and ICE to be doing this, both statutory and regulatory precedent there, and then also moving into kind of the more practical reality. What is DHS actually doing? What is their own take on the law? What process are they applying? We'll talk about some experiences we have had here at Amica Center with third country removal issues in a few short case studies. And then we'll talk about some strategies, both to identify when this might be something that you're about to have to navigate, and also some strategies that we have come up with both in the merits proceedings and also potentially with habeas to fight this for your clients. And we want to leave room at the end for discussion, but if there are questions that come up along the way, feel free to put them in the chat. We will try and monitor that to the degree we're able with our slightly different technical setup today. So, to get us started, where we should always be starting is the law. So, the concept that you are probably all familiar with, at least in theory, is the concept of non-refoulement. And this is something that comes from UN treaties, but the concept is that the United States government and other signatory governments cannot return people to countries where a judge finds that there is the right risk of either persecution or torture. So domestically here in the United States, the way that kind of shakes out legally is that in the Immigration and Nationality Act, 8 USC section 1231 covers withholding of removal, where the Attorney General and the United States government cannot remove people to countries where they are likely to face persecution on account of a protected ground. These are the protected grounds we're all familiar with through asylum litigation and withholding, race, religion, nationality, membership, etc. And then that also translates into protection for torture, specifically under the CAT, the Convention Against Torture, which is an international treaty that we have ratified domestically. The United States government cannot return people, cannot refoul them, legally speaking, to countries where it is more likely than not that they will be tortured. And the regulation citations are on the screen there for you for the two types of CAT protection that your clients might be eligible for, withholding and deferral. One thing that I think is kind of interesting historically and is a good helpful framework for thinking about this for your clients is that when the United States signed on to this treaty and was ratifying it in domestic law, there was this kind of discussion at the time in the government about whether we should reserve ourselves and kind of exempt ourselves from Article 3, which is the non-refoulement article. And at the time, there actually was a reservation about that said that part of the Convention Against Torture wouldn't apply to the United States. But then that was eventually actually deleted by the Bush administration. So that part is fully binding, and the obligation to not refoul people to countries where they will be tortured is presently binding on the United States. So that is sort of the law of where we get started on this.
And Emily, if I can just kind of underscore that too, like for those of you who've studied international refugee law, you might have learned about this principle of non-refoulement. It's like the core foundation of the Refugee Convention where asylum law comes from, and also from the CAT Convention. And so it's kind of like there's no point to any of this almost if we're not protecting that fundamental component of these conventions.
So that's the theory about how a situation might arise where now the government says, okay, we cannot remove this individual to the country that, we would have originally removed them to because either under the INA, they might be persecuted, or under the Convention Against Torture, they would face torture. And so what is the government to do in that case? Legally speaking, they are allowed to seek other country removals. And so that's kind of the point of how we all are here today and what we're here to talk about. So the government has the option to third country remove someone, so to speak, both under statute and regulation. So in 8 CFR section 1208.16, it does note that even if someone is granted withholding or CAT, nothing in that section preventing their removal to those countries would prevent the government from removing them to some other country. And the government then has to decide, okay, what other country can we send them to? And in 8 USC section 1231B, there's sort of this cascading tier list of all the countries that you could pursue removal to. And they kind of go in level of priority. So the tier 1 countries, then tier 2, tier 3. By the time you get down to tier 4, it's sort of the last resort. And we'll briefly talk about all of those, though we are going to today live in tier 4. Tier 1 and 2 are countries to which the non-citizen has some sort of tie of citizenship, nationality. There is some sort of obligation or connection there between the non-citizen and that home country. This is where a lot of clients usually live. in removal proceedings, if the department designates a country of removal, it's likely going to be the country of which your client is a citizen. So they're usually in that first tier or two. Alternatively, if they cannot be removed to their country of citizenship, because, for example, they've won withholding or CAT, then the government could try and remove them to a tier 3 country. That's a country to which they have some sort of other connection. So that usually could be like the country where they were born, but maybe they're not a citizen of that country, or a country where they lived before coming to the United States, but after leaving the country of their citizenship or nationality. And then finally, like I said, sort of the last resort is if none of those are other options, then they can remove individuals to, quote, another country whose government will accept them, essentially. So I think that is something worth noting and that we're going to come back to later in the presentation, which is that this idea of acceptance. The government, in some of our cases right now, has kind of been pushing this argument that, oh, like the other country doesn't need to accept them. We can just unilaterally, as DHS, make the decision to remove someone to some third country where they have no citizenship or connection. This is statutorily wrong and definitely worth pointing out to the government and to any relevant judges. And this is very well discussed in a Supreme Court case from 2005, JAMA v. ICE, where they explain this sort of tiered list of options and are very clear that in order to do this third country removal to a tier 4 country, that country has to accept the non-citizen first. So that is something to keep in mind as we move forward. So to kind of, that's the law. That's sort of the abstract where we are. What does this look like on the ground? So we're going to break this up into pre this year and then this year, because as I'm sure everyone knows and has experienced in all parts of your own practice, those are two different realities that we're living in now. Pre-2025, this was exceedingly rare. This was discussed in a Supreme Court case, Johnson v. Guzman Chavez, where I think it was Justice Kennedy, one of the justices had a relatively decent explanation or discussion of these third country removals and noted that at the time in the fiscal year 2017, only 1.6% of non-citizens who were granted withholding or deferral were actually removed to a third country. This was, as everyone had kind of experienced up until this year, this was exceptionally rare and often would involve situations where the non-citizen was like a dual citizen and they won protection as to one country but could maybe be removed to the other one. More recent data shows that this remained very rare even after 2017. From data that we were able to pull from fiscal year 2020 to 2023, we found only 5 individuals who were actually removed to a third country after winning withholding or CAT. So again, out of the many citizens, the non-citizens to which this might apply, this was very rare. But for the ones where it did happen or where it was at least pursued, the theory was that after your client, for example, was granted protection, withholding, or CAT, then their deportation officer, because this primarily happens for individuals who are detained, their deportation officer would file one of these Form I-241s, and an example is on the screen so you can see what it looks like, where the deportation officer would basically fill in the information about, where they're from, the person's name, date of birth, etc., and then they would send it to the consulate of foreign governments. In theory, the governments that they chose to send this to were supposed to fit certain criteria. Like maybe there's some linguistic or cultural overlap between the country of citizenship of the person at question and this potential third country for removal. But it also, practically speaking, is very arbitrary. They'll pick 3 countries and send these emails and these forms and basically have checked that box. These countries have no obligation to accept these individuals or even respond to ICE. And so what is our experience is very common is that the deportation officer sends off these 241s, kind of like sends an email off into the void, and they never get a response. Or if they do, it is almost always a no thank you, we don't know this person, we will not be taking them. But in that period of time, the regulations do allow for the non-citizen to be detained while the deportation officer pursues this third country removal. And that's under 8 CFR 241.4. There are custody reviews that are supposed to be happening every 90 days. As we all know, DHS isn't really great at following their own regulations. So whether this is actually happening every 90 days or not, sort of up for debate. But in theory, the process is that while they pursue third country removal, they are at least reviewing every 90 days if they should keep holding on to this person. And they're supposed to give notice to the non-citizen and their attorney if they have one. And they base it off of flight risk and dangerousness, sort of like a bond hearing. And then they also consider foreseeability of removal. In pre-2025 experiences, a lot of people would actually get out in this posture. They had won withholding or CAT as to their home country or their country of citizenship. And then DHS, knew that they weren't going to be able to effectuate third country removal. So either at the 90-day mark when they did this custody review or before that, they would often release the person on an order of supervision, which we're not going to, order of supervisions are their own thing. We're not going to talk about today, but that was at least the experience on the ground before 2025. But because we are not in pre-2025 anymore, I'm going to turn it over to Genesis to talk about this year.
Yeah, so now that we're in 2025, there has been this guidance set out by DHS on third country removals. And one of those options of these third country removals is through diplomatic assurances, basically agreements from these other countries that assure that they're not going to harm or mistreat someone if they are moved to that country, right? So if there's like any credible diplomatic assurances here, there's no notice, no process to the person. But if there's no credible diplomatic assurances here, then there is some type of notice and some type of process, right? So then we're looking at option 2, no diplomatic assurances. These notices, you're supposed to get a notice, but really it's a shout test for fear at this point. Your clients could be saying, I fear this, I fear going to such country. If they even have a notice of like where they're going to, is ICE really gonna listen to them? Maybe, maybe not. Once your client affirmatively actually states their fear, they're supposed to have a screening set up by the asylum office at USCIS, who screens their fear for eligibility for withholding and CAT relief. Usually the screening takes it's supposed to be scheduled within the 24 hours. However, again, that is not realistic sometimes. Sometimes it could take days, sometimes it could take weeks. It really just depends on where you are. And the standard that they apply during these screenings are the more likely than not standard. So it's definitely a different standard compared to the reasonable fear interview or a credible fear interview. So at the asylum office, you have to show, basically we have to show in court a more likely than not standard, which is definitely outrageous to show during a screening. And if you're found negative, which I don't think we've heard of any like positive findings yet from anyone. If your screening is negative, then you are removed or to that third country. But if it's positive, then DHS can move to reopen your case or find another third country.
I've heard of one positive determination
Really?
so far, but it was just one. So I hope we hear of more.
And Genesis, so what do you all do when someone finds out they got a negative? Like, what's the next step?
Yeah, we're going to talk about it later in the presentation.
Cool.
But I do think it's worth highlighting this point, the last point that Genesis said. Even if you win the fear screening, DHS has given themselves this wiggle room where they don't have to actually reopen your client's case. They could just say, okay, you've shown this fear as to, for example, Mexico or Nicaragua. So we're just going to try again. And now we're actually going to try and remove you to some other country. And you kind of just get stuck in a wheel. So I think that is worth highlighting, that they've left themselves this loophole to cut off your client from process whenever possible.
And so where are our clients really being taken to? There are these third country agreements between Costa Rica, El Salvador, Guatemala, Kosovo, Mexico, Panama, Rwanda, Ghana. There have been at least about 10 to 11 reports of direct refoulement, but there have been so many instances of chain refoulement, especially within this last half of the year. Yeah.
Where are you seeing most of the chain refoulement come from?
I think, I've only had Central American clients that have gone through Mexico, and then Mexico sends them to their own irrespective countries, home countries.
So I was just checking the chat and I saw there were a couple questions. The slides will be shared. And I am very pleased that, Lucelia, you got a positive R5 screening. We love to hear it.
It's great. If you have any tips, please put in the chat for others to see.
Yes, we'd love to learn from whatever you did well in your fear screening. Okay, next slide. So we want to briefly share a few case examples here of our own experiences in-house with third country removals to kind of give you maybe a little bit of a foretaste of the somewhat unfortunate experience, which is that it's really hard to say what this is going to look like in your cases because it runs the gamut between tons of needing to work on third country removal to there was very little risk of third country removal. So we had a habeas case recently for AA, and that was an individual who had been granted withholding as to their home country. And in that case, we waited the normal amount of time after he won his case and then filed a habeas for him. And in that case, the government made almost no attempts to really actually remove him to a third country. They sent those 241 forms that we talked about earlier in like March, and then did absolutely nothing about it until we filed our habeas in October. And so then the court ordered him released through habeas because they said, like, you're not taking any steps. This is really unserious. And also you've chosen countries for this hypothetical third country removal where this individual faces all the same risks that they would have in their home country. So that was an example of, thankfully, a very easy third country removal situation where it actually really wasn't something we were super concerned about. On the flip, we had a case for OO, another habeas, where the government did attempt a third country removal, and we had to file an emergency temporary restraining order in the habeas proceeding because they were trying to third country removal this client to a country where we knew there was a lot of this chain refoulement happening. And so then we had to file other things in immigration court to get her case reopened. So that was a situation where sort of the same situation, client had protection as to the home country, but there was a lot of work that needed to happen on this third country removal issue. This is being challenged at times. There was a case in the district court for the District of Columbia here, DAV Nome, that challenged this idea of chain refoulement. In that case, they were challenging an unfortunately well-documented pattern of chain refoulement from Ghana to people's home countries. So it was a lot of individuals with protection, withholding or CAT as to their home countries of the Gambia and Nigeria, for example, who were being sent to Ghana, and ICE was even telling them, we're sending you to Ghana and Ghana is going to send you home. And so it was this very clear runaround of the non-refoulement obligations that the United States has. Unfortunately, in that case, because of sort of the situation that was at play there, the court found that they had no jurisdiction to even hear this issue and to offer relief because they would essentially be ordering the United States government to order Ghana to act in a certain way. And so that is something like, this litigation is still on, not this litigation is not ongoing, unfortunately, but other litigation, I'm sure it will be coming on this issue, but to give you kind of a bit of a flavor of what you might be looking at. Genesis also mentioned, unfortunately, the risk of direct refoulement, where someone is sent directly to the country to which they have withholding or CAT. As she mentioned, we've heard about this unfortunately happening 10 or 11 times already that we know of. And unfortunately, that probably means it's happened more for individuals that we just don't learn about or they were pro se. And so that can be challenged in court. We're actively doing it for a client. It's been litigated in other courts as well to try and bring them back from the country that they were unlawfully removed to. But there's also a lot more direct on the ground experience. So Genesis, tell us a couple about a couple of your cases.
I know we've had a lot of experiences at DAP more recently, and for one of my clients, he was chain repelled. He won protection. He's from Honduras. Won protection. Was detained for what, like 5 months, 4 or 5 months, and then we tried to do a motion to reopen to at least stay his removal, right? But unfortunately, the judge just denied his motion to reopen, and so my client honestly was just very tired of being detained because detention fatigue is very much real. So he ran the risk of being removed to Mexico, thinking that they would at least provide him asylum. And instead, the reality of it, and we already knew what was going to happen, was that Mexico was going to send him back to Honduras. I know Anna from the legal orientation program division of our department also had a situation where her client was removed to Ghana and then sent to Gambia, his home country, more recently as well. So those are some of the what we're seeing. We're still trying to actively stop people's deportations through motions to reopen at EYR or motions to reopen at or appealing these decisions to the BIA. I've had only one success of a stay of removal for an appeal based on the immigration judge's decision on denying the motion to reopen to litigate or talk about my client's fear of removal to Mexico.
And we will talk about some of those more procedural tools that you have in a few slides, but thank you so much. I think this does show kind of just you never really know exactly what's going to happen, but this is maybe a taste of some of the options so that you can see it in your own cases and be ready for it.
So I think at this point you're asking how do I know, or how do I know when things are happening? So again, individuals at this stage have already won their case. They've either have won their fear-based relief from their home country, or their country of citizenship is not accepting them at that point. We're seeing that it's a higher risk for clients from Africa or Central or South America. We're also seeing a high risk for individuals with dual citizenship or have significant connections to other countries. Also, if higher risks, if ICE has requested that the client sign anything regarding travel documents. But another one is, and one that I've seen mostly with these third country removals, are when ICE serves a notice of intent to remove. So we have an example right there of what ICE has done. Precisely, they just hand these people or hand the clients this notice. They make them sign. Obviously, who's going to sign that? But this is your sure notice to basically have the red flags of trying to do something for your client at this point.
I saw a question in the chat about kind of what kind of notice and deadlines are available. There are no deadlines. Unfortunately, this is something that, for better or for worse, there are very few regulations about third country removal and what process is afforded in that situation. Just because I think before this year, it was never really used or really contemplated being used in the way it is today. So I'm sure a lot of you have been tracking the DVD litigation out of the District of Massachusetts, which is all about this third country removal issue. And a big part of that litigation was kind of trying to figure out what kind of notice and what kind of process should even be afforded, because there is no regulations that's actually prescribing that. So when Genesis was talking about this notice of removal, that is the notice, unfortunately, that we're seeing a lot of times. And as soon as that is in your client's hands or in your hands, maybe they will serve you with that as well. But if not, definitely the client, then the deadline is as soon as humanly possible, unfortunately, to file some of the things we're going to talk about in the future.
And Genesis, did you receive that form in your cases?
Yeah. I received it twice. So from Farm Bill, once I received that, I had 2 or 3 days after my client was going to be removed. But in Louisiana, I had a week or two, a week and a half before they even tried to do anything. Yeah,
so the timelines do vary. But we've had clients where they get this notice and then a fear screening is done very quickly. And then sometimes, like I heard one situation where there was like a month between getting this and the fear screening. So unfortunately, there are no prescribed deadlines to the question in the chat, unfortunately. So there's a few different options that we wanted to highlight here based on our own experiences. And obviously this is a really evolving area. So we are excited to open it up for some discussion after this. But there's a few areas where you might be able to kind of get ahead of this third country removal issue. The first one is if your client is still in proceedings, you can lay lots of groundwork at this point. There are situations where you can, on the record, have your client talk about any fear they have to other countries. I will note the immigration judge cannot just preemptively grant relief as to countries that aren't designated. So like if your client is from, for example, Honduras, and that is the country DHS has designated for the removal proceedings, and on the record your client says, and by the way, I also have a fear of going to Mexico, that's great, and it's good to get that on the record, but the judge is not going to grant your client withholding as to both of them. But it can be helpful to lay the groundwork, put DHS on notice that there are other countries to which your client has a real fear of return. If your client is no longer in proceedings, which I think that's the situation we're seeing this in for most of our clients, then the fear interviews are a great opportunity, though hopefully we can all emulate Lucelia's experience and get positive fear screenings here. But it is important for your client to very clearly and repeatedly express fear. Like Genesis said, this is a shout test. ICE has been instructed to not ask your client if they have a fear of going to whatever third country they've identified. So it's on you and your client to be on record as much as possible in writing. Email the deportation officer, file a letter, have your client tell every ICE officer they ever talk to, hey, by the way, I have a fear of going to whatever country has been identified. Like we've said several times now, there's very inconsistent experiences as to the timeline. So if you think your client might be coming up on a fear screening, you might need to be ready to move pretty quickly to be present for the fear screening, which will happen on the phone. But it's something that you should really, really push hard to be there for. There are usually no transcripts of this fear screening. And so you want to be there to take your own notes and be aware of what your client has told the officer, and also push to submit evidence in advance. Ask, where can I email evidence? Where can I file things? Unfortunately, they may not accept it, but you are on record as having tried. And also, I will flag, you may be familiar with doing reasonable fear interviews or credible fear interviews with your clients. Those are prescribed by regulation and offer immigration judge review of any negative fear finding. This is not that. And it is DHS's position that these fear screenings are not eligible for IJ review. There's ways to challenge that to try and get IJ review, but just as a general course, if your client is given a negative fear determination, they will not ask your client or give your client a ton of opportunity to try and bring this up with an immigration judge. So then you are left with options for motions to reopen and stays with the immigration court or with the Board of Immigration Appeals. So it depends where you want to file those, sort of depends procedurally on where your case was at the end. So if your client won withholding, for example, or CAT, and DHS didn't appeal, and therefore your client's file is still with the immigration court, that's where you're going to file the motion to reopen. If it was at the BIA, that's where you're going to file it there. And it is not guaranteed. We want to be clear, like this is, like I said, an evolving area. So we're still trying to collect stories of people's experiences. It's not really always clear how they're going to reopen your case. They could reopen the case and say, great, now we're in basically mini proceedings only as to the third country. Let's say, for example, Mexico, if your client is Honduran. There is a chance that the immigration judge, especially if they are not friendly, may reopen the entire case. And then your client's original grant of protection could be sort of back in discussion. So that's something to be aware of. And when you're writing your motions to reopen, being really clear that what you're asking for is for the case to be reopened as to a newly designated third country of removal, and like leaving the original case completely undisturbed. Something we are seeing kind of mixed results from is whether immigration judges, for example, when adjudicating motions to reopen, are going to consider this real reality that we know about chain refoulement. Some judges, I think, are at least open to considering that will have to figure into your client's fear of removal to that country. Especially like for cat, as we all know, for cat relief, you aggregate all the possible sources of harm. And so an immigration judge could consider the risk both in the third country and in their home country if chain refouled in that decision of whether or not to reopen your client's case. So it's very important that you include all of that in a motion to reopen and say, I saw some conversation in the chat about like, how are we proving this? There's news articles, there's different reports, there's litigation that is ongoing about these types of issues that you can cite to. For example, if your client is facing third country removal to Ghana, I think it's a great idea to cite to DA v. Nome. And unfortunately, legally, that didn't help, but there were a ton of facts in that case that would be really helpful, that were very well documented and largely not disputed by ICE in that case, actually, about the reality in Ghana, which is that people are being chain refouled from Ghana to their home countries, particularly Nigeria and the Gambia. So those are the types of things you want to be attaching to the motion to reopen. And this is unfortunately a little bit of a kitchen sink situation. Like if your client fears going to that country for any reason, definitely recommend including it in the motion. And for those of you who are practicing with some non-detained clients, especially those who are out on orders of supervision, I would recommend that you maybe check in with them if they have check-ins or court hearings coming up, any type of interaction with ICE, frankly. And you may want to be aware that if they have a check-in coming up, they are subject to redetention, and then you might be facing this issue, and you may want to start researching a little bit of a motion to reopen or a stay in their case if that were to come up for them. Alternatively, and often in parallel, you may want to consider the viability of habeas for clients who are in this position, and maybe ICE is allegedly trying some sort of third country removal, but they've kind of just been sitting around in detention for a long time. You may want to consider habeas. I want to be very clear about what habeas can and cannot do, unfortunately, for your client. It is a powerful tool, but not an everything answer. So through habeas, you are challenging ongoing detention, not the country choice of third country removal. For example, you may think, and I almost assuredly agree with you, that the third country that ICE has selected for your client is the wrong country. It is inappropriate. It should not happen. That is not something that habeas will really be able to get you. What usually a habeas will get you is ICE is trying, they are clearly not succeeding at removing my client to some third country. Maybe they're not actually even trying, who knows? And so their detention has become too long. A risk that we always talk about with our clients who are in this posture is that through the filing of habeas, you may be lighting a fire under ICE to actually do something and actually give it a little bit of effort to remove them to a third country. We have seen that, unfortunately, in some of our cases, that ICE wasn't taking any steps really to third country remove the individual until we filed the habeas, and then they're much more motivated now to be able to show the court that they're doing something. In that case, your habeas may actually moot out, but depending on your client's situation, it might still be worth it to you and the client to at least try and be able to get them out of detention. You can, in your petitions, and we will be, when we send the replay and the slides, we will also be sending a template petition, habeas petition, kind of highlighting some of these third country removal issues. And you can raise claims under Zidvitas v. Davis, which is sort of the seminal Supreme Court case on detention post-order, and also due process claims, if applicable, in your client's situation. And one of the things that you'll see in the template that we pass around is that you want to be highlighting facts that show it is not significantly likely that your client is about to be removed. They can't be removed to their home country, usually, like we've said, because they have withholding or CAT. It has been historically incredibly rare, some of the data we mentioned earlier, for this to actually work out for ICE. There seem to be no options on the table right now for third country removals. And it's worth noting that even though the process that DHS has set out in their memo that Genesis talked about is lacking and probably is a huge due process violation in and of itself, it is some amount of process. And so it's worth highlighting to the habeas court that even if a third country were identified, it doesn't mean that your client is actually going to get removed anytime, because it might just spawn some new proceedings. One thing that I personally have found really actually very insightful through this type of habeas litigation is that it's a good way to actually find out what the government is doing, because otherwise you're not gonna know. They're not usually telling the client what country they've sent these 241 forms to. They're not telling you, definitely. And so through habeas, they're going to have to produce something. They'll usually produce a very generic affidavit, I'll say, from an ICE officer that says oh yes, we've definitely taken steps. These are the countries we've picked. We emailed them 7 months ago, so this is totally still going to happen. But that's helpful for you because you didn't know what countries were identified previously. And then your reply brief can be a place to really push back on that and say, this evidence is absolutely insufficient to show that my client is about to be removed. You can say, for example, and I think all of these have applied in some of our cases recently, they have chosen completely inappropriate countries. Like I mentioned with one of our examples, the judge even noted that the countries that they'd picked for third country removal were incredibly inappropriate because he would have faced all the same harms there that he would in his home country. And so definitely highlight risks to your client there. You can highlight the fact that these countries have not accepted your client. To our point earlier, JAMA v. ICE, those cases, the government has to accept the person in advance in order for third country removal to be really feasible. And so you can show it's not enough that ICE emailed them. These people have not even responded, much less actually said, yes, we'll take this individual. Even if there's acceptance, there might be some wiggle room to argue, there's no travel document. Maybe your client has no passport. So how are they going to get to this third country, even if that government is willing to accept them, which again, they're likely not going to accept them. It can be helpful to highlight the lack of expected timeline. So even if someone's accepted, the government hasn't produced evidence that oh yeah, now that they've accepted, we can remove them in a week, 2 weeks, a month, however long it is. And I think what you might find more often than not is just that ICE hasn't actually done anything. And that's good for you in one sense, because it is good evidence in your reply brief that removal is not significantly likely because ICE hasn't even looked at your client's case in months, much less actually tried to do anything to remove them to some third country. So that is something that you can definitely consider. And you'll see some of those arguments in the template habeas that we'll send around after this roundtable. So now we do want to open it up for you. I will try and pull up the chat right now, but then also please just feel free to come off mute. These are some questions that you may want to answer or may just share your own experiences. What are you seeing in your cases with your clients? Have you experienced any of this yourself? What are you hearing? We'd love to hear anyone's experiences in this rapidly evolving area. I'm seeing a question in the chat about the shout test, if your client has to specifically identify countries or if they can just identify a persecutor. I'm afraid to be sent anywhere. Great question. I think, factually, the more specific, the better. If your client has already received a notice of intent to remove, then the relevant fear that they should be shouting everywhere is fear to that country. If your client hasn't gotten to that point yet, I think it's helpful. We have had some clients where we submitted just a general fear letter that said, I'm putting ICE on notice. I have fear to other countries, including but not limited to, and then if there are any particular countries that they have a special fear of, then that is helpful. But it's good to leave it open-ended because there are many countries in the world, and as we are seeing, unfortunately, ICE is not really considering a lot of linguistic or cultural or geographic overlap in trying to figure out where to send people. But that was a great question. Thank you, Rachel.
I can talk to that.
This one?
Yeah.
Yeah, go ahead.
Okay, so I think when you go about requesting these interview screenings, it could it really just depends on the facility. I've had experiences where I just said it directly to the deportation officer in Louisiana, and he said, okay, great, like I'm gonna set this up. But I've had the experience where I'm shouting to every single deportation officer, SDDO, maybe an AFOD. I've CC'd everyone, no one is listening to me. I have gone directly to the asylum office and requested that interview itself. And then the asylum office is going to communicate with you when they're going to schedule it for you. And you can even ask like for a paralegal to be on there, and for you to submit all your evidence in advance. Unlike my other experience with just doing it with a DO, my client was even able to have me there because the interview was done on Saturday, and apparently it was illegal for me to be there, which is crazy. But I think it's because apparently they didn't have my G28, which is again wrong. But that has been my experience so far. It really just depends on the facility at this point.
There's a question from Megan about if there's a sense that female clients are less likely to be third country removed than male clients. Unfortunately, our observation is no. Everyone is at equal risk of this. I have definitely heard of female clients, ours and others, being third country removed, or at least identified for third country removal. I think, unfortunately, that is sort of the reality we're in.
Yeah.
Looks like you got a hand up.
Oh, yes. Gabrielle, please feel free to come off mute and either share your experience or your question.
Hi, yeah, I just wanted to share my experience with folks. I had a client that was granted withholding of removal here in Colorado. And then he was transferred to the Leavenworth, Kansas federal prison. Um, he was there for the whole 7 months post-grant. During that time, I was trying to communicate with ICE. It was hit and miss a little bit. But I did just want to say to folks, if you're feeling really frustrated communicating with ICE, that no matter what answers they give you, even if they're factually incorrect or incorrect based on the law, um, they can be helpful later. We actually won his habeas case and he was released without a bond hearing. And the judge actually cited to the emails that two officers sent me on different occasions that they weren't pursuing a third country for removal. And so one officer even told me because he got granted withholding of removal, he couldn't be deported to a third country. And I was like, okay, cool. I would love for you to keep believing that. And so I just want to throw it out that like when I was going through this with my client, this is a really difficult issue and really stressful, but as much communication as you can get with ICE as possible, I think it can be helpful later in the process, especially if you make it to the habeas step.
Thank you, and congratulations on the release. That's huge. Definitely agree. Lucelia, I see your hand is up.
Hi, yeah, I just wanted to share my experience. My client got picked up at an ICE check-in. So she had been granted withholding in 2012. And, I had to kind of chase her down through New Jersey, Texas. She's now in Arizona. And we requested the day after she was detained, we requested the reasonable fear interview in May of this year. She didn't get an interview until the Sunday before Labor Day, so August. Um, and at that time, the asylum officer did find that she was more likely than not to be tortured in Mexico. Um, But as I understand the memo, it is when that happens, it is DHS that needs to do a motion to reopen. And in this case, the case was just referred over to the immigration judge as if this is just withholding only proceedings. And we had a full hearing, and then the judge, without much analysis, determined that she did not meet the burden of being more likely than not tortured in Mexico. He did not address my arguments for refoulement whatsoever. And right now we are on appeal to the board. The only, I guess, silver lining is that ICE kind of conceded that they can't deport her until the appeal is finalized. But we are on our second habeas for her.
Wow. Thank you so much for sharing and for fighting so hard for her through every type of mechanism, frankly. Peter, I see your hand is up as well.
Yeah, and I began to put mine in the chat a little bit, but so I guess I'm in maybe a more advantageous posture, an earlier posture. We're still at the individual hearing stage. We have had several iterations of this individual hearing. I've got another one coming at the end of January. The government just went ahead and filed notice of their intention to pursue third country removal, as a piece of pre-hearing briefing before we even got to the merits. So we put some opposition in our opening brief. The court so far has said, they can designate wherever they want. I'm not going to bar them from designating that. And, we can sort of fight about it later. So I guess my question and my takeaway here is the best thing I can do at this point put in evidence in the record of chain refoulement? I mean, someone else thought, well, just file a whole separate 589 presenting a distinct cat case from Mexico. I think I'd have a harder time winning that than I would his cat case to El Salvador as it is. Anyway. Welcome.
Yeah, I think it's,
yeah.
Oh, I was going to say,
I guess I'm just sort of sharing that other example and just trying to look, seeing what you think strategy wise.
Yeah, I think it's hard when it's not technically a designated country, if I understood the factual scenario correctly, because if it's not a designated country, then IJ really can't, unfortunately, grant relief. But I think if you put evidence in the record, I'm not sure you need to put on an entirely new cat case because it's not a designated country. But I do think that fear on the record is helpful. One of the plaintiffs in the DVD litigation was from, I believe, Guatemala, but had in his proceedings to Guatemala mentioned his fear to Mexico, and the court did find that convincing that DHS was on notice of that fear. So I do think that is helpful to get on the record if you can.
Yeah, I guess is it more important the fear of Mexico engaging in chain refoulement, or more important just fear of harm that may come to him within Mexico?
All of it.
Yeah, all probably. Yeah. And I mean, the benefit of a CAT analysis is that the IJ is required to consider everything in the aggregate, basically. Yeah. So all fear contributes, even if it's a grain of rice, it's on the scale that might tip the scale. I'm seeing a couple of questions about timelines in the chat. There was a question from Kirsten on the timeline for filing and release for habeas. I'd love to tell you that there's a firm timeline. It varies wildly between courts and judges in specific courts. We will see, some of the habeases we do now, it's a month from filing to release. Sometimes it's a year. I wish I could give you a little bit of a better thought on that. And then there was a question from Sude about release. Genesis, I'd love to hear from you, but we have not seen any clients released this year without a judicial order, either because they won IJ bond or they were out on a habeas grant. Have you seen anyone?
No.
Yeah, I think discretionary release, unfortunately, is dead. Not to be too macabre about that. And then, I think Olivia put in some comment about having DOs mention that they don't know anything about third country removal. I think that's probably fair. A lot of DOs actually, up until this year, probably, if they knew about it at all, they did it as a formality because it never worked out. We've had a DO put in an email that we saw that they said, oh, it never works out. I do think things have changed this year, unfortunately. I realize we are close on time, but Malak, I'm sorry if I didn't say your name correctly. You've had your hand up for a couple minutes. I want to make sure that you get a chance to share.
No problem. I just wanted to quickly share a recollection from a client I consulted with recently. She was a Russian national who was granted withholding of removal maybe 10 years ago. She has routine ICE check-ins. And in her ICE check-in this year, they told her to go to a number of consulates, and she didn't remember the countries, but a number of consulates for different countries in New York and get letters from them saying that she could not be returned there. I wanted to share that in case anyone else had that experience, but it was related to the argument or the issue of third country removal. And she needed to get proof that she couldn't go back to those countries and have it ready for her next scheduled ICE appointment.
Thank you for sharing.
Yeah, that used to be how things would work back in the day with like traditional as advitus habeas claims when someone was ordered deported to their country and the government couldn't carry out that deportation. The ICE officer would want them to go around and get letters from the other countries saying they couldn't go in order to pursue release. So that's interesting.
I think
in terms of the timeline question, someone asked, do you want to speak about like the 6-month mark?
To go back to the habeas question, the question had been about like how long from filing to release, but I do think that one thing to flag, and you'll see it in the template motion that we send around, Zedvitus contemplates a 6-month presumptively reasonable timeline for post-order detention, kind of saying, okay, you got to give ICE some time to try and figure this thing out. And I will note that that is a rebuttable presumption. We have had success with that. There are several courts in the country that have also agreed that it is not a bright line test. ICE will tell you it is. ICE will always argue that any habeas filing for a client in a post-order position before the actual 6-month mark is not ripe for adjudication. And unfortunately, some judges are swayed by that, but it is worth trying, especially if there are other factors at play. So the template habeas we'll send out has both of those alternative arguments, both about why you don't have to wait a full 6 months, and also if your client happens to be beyond the 6 month, obviously that makes your life a little bit easier on the habeas front. There was an interesting thing in the chat from James, and I see your hand is also up if you want to ask it on microphone.
Sure. Yeah. Thank you. I don't want to open up a whole can of worms with the ACAs, but I am seeing a lot of motions to pre-termit and remove people to third countries under this new matter of CIGM. Any advice about how to contest those other than just showing fear of return to that third country would be really appreciated. But one thing you mentioned earlier I was wondering about was saying that with third country removals, generally you have to show that there's an agreement with the third country to receive this person. I was wondering if that could be brought to bear in these cases, because as I said in the chat, the Honduras ACA, for example, only contemplates receiving 10 people per month or 120 people per year. So, obviously the government is not showing that there is, a forehand agreement to receive any given asylum applicant who's facing this sort of motion. So any thoughts on how to combat these sort of motions to pre-termit under matter of CIGM and ACAs would be really appreciated, but also I know we're at the end of our time. Thank you.
Yeah, briefly, and I will just say I'm a no matter of CIGM expert on pre-termission, but something that does come to mind is I think it's actually a really strong point that you make about saying like, pull from this type of case law, JAMA v. ICE, for example, and say, and the actual language of the statute, and say they have to have been accepted by this third country, and ask that the government have to produce something. Is there a list? Is your client on the list? Is there some sort of list of people who have already been approved to be taken to whatever country under the agreement? Because my sense, based on nothing but my own instinct on this, is that they are using this argument in way more than 120 cases every year. And so I think it is helpful, get them on the record about it and make them, or ask the IJ to make them, state on the record what's the likelihood of this actually applying to your client. I do think that is a really good argument to make in an otherwise tough situation. Definitely.
And I think CGRS and NIPNLG have great guides on how to combat those issues as well with ACA pre-terminations.
Perfect. Thanks. Yeah. I think we are at time, but thank you guys so much for coming. I'm sorry we probably couldn't answer everything in the chat. I am realizing there were more things in here that I didn't even see. But thank you so much. If you have cases that are in our area that you would like to refer, as Adina mentioned, our email is in the chat and we will be sharing the recording and the slides later. But thank you so much for coming, everyone. This was very well attended. We really appreciate everyone's time in these incredibly stressful periods of all of our practice.
Thank you, everyone. Take care and have a good rest of the year. We'll see you in 2026 for the next roundtable.